before bringing the record. I'm praying for an adjournment today.
Lordship, I'm out of service since 2020. It may be fixed in July because the record is actually required. 17 July, Lordship. Deeply obliged.
Item 30, request made by appearing to the bank.
Lordship, respondent bank.
On 70th, Radhida.
Deeply obliged.
Lordship, the mention maybe regarding the record, that may be also
The record relevant
to the discipline.
record, the kept ready for medical.
Deeply.
May I please, Lord? Also, I make, then item number 33, my lord. My lord, we have filed an IA, my lord, in main case, my lord, praying for extension of time, my lord. So, my lord, this matter may not come after vacation.
For vacation.
Yes.
I'm for the petitioner here. Now I have received this application. They are praying for 6 months time.
We don't know that the application.
Yes, ma'am. That
Item 33 says record that the made by made by that topic that is the IA along with concept text. It's the we did it after on
18th.
18th.
May I please, your lordship? I like to mention item number 25, lordship. In this case, lordship, private respondent number 2 filed an additional affidavit on 19/6/2025. lordship. We want to file a rejoinder,
There was
lordship.
a petitioner.
Petitioner, lord.
Your name?
M. Hussain.
The affidavit filed by
Respondent number 2. Much of.
Please, Your Lordship. So I beg to mention item number 31 in the concern of the petitioner. They have filed the additional affidavit. We, respondent number 5 and 6 would like to file and reply. They are the main respondent. 31.
31.
Yes.
Who's appearing for 31?
5 and 6.
Petitioner.
She is
I'm the petitioner.
You have filed some.
Lordship, we had filed an additional affidavit. They want to file a reply to the said affidavit.
That but one that after the namely the
5 and 6.
council for respondent 5
5
and
and
6.
6.
Time to file the reply.
So, Lordship, 23rd of July, if possible.
23rd of July.
Yes, Lordship.
Acha, right.
Highly obliged.
May I please, your lordship? I beg to mention for listing of a review petition, my lord. Only Thursday, my lord.
What?
My lord,
When was it filed?
my lord, it was, my lord, pending matter, my lord. The similar petition, my lord, has been already disposed of, my lord.
When do you want it?
Thursday, my lord.
Thursday.
I'm deeply obliged.
registered deed.
Thank you. This is a contempt petition, my lord, against the judgment and order. Lord, you will find the judgment at page 17. In fact, it's a common judgment, my lord. Page 17 and the operative portion, page 28, your lord. That order has not been complied till today. Relevant portion, paragraph 17.
If we get that direction continuing, it
But here, four read petition, my lord. All read petition are numbers are separate, my lord. I'll give the numbers. But judgment order is common.
how many
Item number
petitioner here?
4, my lord.
4 petitioner.
Yes. In this case, only one, my lord.
That's what- He appeared in, he was the petitioner in which matter?
He was a petitioner in, my lord, WPC 3719. Page 18, your lordship will. Komoloska dot.
So the participant is 6710 of the petitioner by the PP 719. So the judgment, the respondent were directed a prepayment. The order within a 3 months. The date is submitted that 5 of the order be brought. Directed. Like, immediately. The it's yeah.
In item 3, my lord,
Arising out of the same order.
same order, only read petition number, your lordship will find page 1717. WPC 3710, my lord, 2019. In item number 4, your lordship will find the read petition in page 18, my lord, 18. 3719, 2009. Wait, please, your lordship. Well, in this matter, your lordship will find at page 19, WPC 4349, below my page 19.
4349.
Yes, madam, 2019. Oh, yes.
Wait, please, your lord. Yes, lord. This is a promotion matter. The rank of warrant officer. Petition has been denied promotion on the medical ground. Although on the 16th of November 2023, medical certificate has been issued where he has been found perfectly physically and mentally fit in shape 1 medical category. Despite petition has been denied promotion.
Yes,
Which is same in the
Okay,
next 5.
quick. Paul,
All, my lord.
the way rise in after 4 weeks.
May you please your lordship pass over the matter for the time being. The engaged counsel is another court.
Next is your lord. Regarding non-payment of lordship service benefit to the petitioner lordship during the period of his dismissal from service till his reinstatement lordship. By an order of this honorable court lordship is dismissal from service order was set aside lordship.
What was the direction conveyed?
Lordship. Page lordship 21. Paragraph 14 lordship. May I read lordship? In view of the above finding, it would have been a fit case for remanding the matter back for giving an opportunity to the petitioner to cross-examine the 6 departmental witnesses who were examined during the departmental proceedings. However, the fact remains that inquiry proceeding was drawn way back in 2017, and not only that, the entire departmental proceeding records have been misplaced, and despite all the attempts made by the respondent authorities, the same could not be traced out. Under the circumstance, it will not be possible to remand the matter back so as to give an opportunity to cross-examine the departmental witnesses. Therefore, under the unusual facts and circumstances of the case, this court is of the considered view that ends of justice will be served if any other penalty other than the penalty of dismissal from service is imposed upon the petitioner. Thus, having regard to the decision of the apex court in so the matter is remanded back to the disciplinary authority to impose any other penalty upon the petitioner except removal from service within a period of 6 weeks from the date of receipt of a certified copy of this order. The disciplinary authority shall also determine and pass appropriate orders regarding the entitlement of petitioner as well in accordance with law. The impugned orders dated 18/1/2017 and 25/7/2017 are hereby set aside. Your Lordship, 18/1/2017 is the order of dismissal and 25/7/2017 is the appellate order, Lordship.
Now, you are ultimately,
Was reinstated, I'm
Reinstated.
reinstated.
but there was no direct, you will go back with.
Yes.
Direct,
It was ultimately set aside, Lordship.
but does give you automatic back.
Lordship.
Will have, what will have done a finding that the entitled back,
But my lord, I have
how
found,
period that cannot be served.
well, I have found in the FR 54A, it says
For a
54A. May I read, Lord? FR 54A, where the dismissal, removal, or compulsory retirement of a government servant is set aside by a court of law, and such government servant is reinstated without holding any further inquiry. The period of absence from duty shall be regularized and the government servants shall be paid pay and allowance in accordance with the provisions of sub-rule 2 or 3, subject to the directions, if any, of the court law.
Examine.
Lots.
Because of following. Regional. That is on behalf of all.
All the respondents.
Obliged.
Since on the basis of this honorable court order, Lordship may dispose of matter, this compassionate appointment matter. And in earlier occasion, this petitioner approached this honorable court because of the OM 18/9/2024. I've been told to withdraw. Accordingly, it was withdrawn and it was filed fresh, my lord. Now, my lord, this honorable court, Lordship kindly have a look, my lord. This 18/9/2024 has been discussed by this honorable court. And subsequently, Lordship kindly have a look at page 67, my lord. Abdul Qadir Bakshi and others, my lord, there are series of cases. Now, mainly in page, the para 9, 9 and 10 are the direction, my lord. Page 73, Lordship.
Yeah.
May I read, Lord? In view of the consent of the learned counsel for the parties, all the writ petitions that are pending as on today, 3/4/25 in the Guwahati High Court, which have put to challenge the impugn OM 89/24 are to be decided as follows. All the applications for compensation appointment submitted by the petitioner shall be considered and disposed of by the concerned DLC SLC on merit by taking into consideration the various guidelines prior to 1/4/17 laid down by state government for compensation appointment and the judgment of the Honorable Supreme Court and the High Court. Consequently, the rejection of all compensation appointment by the DLC SLC, which have been put to challenge and are pending in the Guwahati High Court as on 3/4/25 are set aside. The entire process for considering the various applications for compensation appointment and decisions to be taken in each case by the concerned authorities should be completed within a period of 6 months from the date of receipt of the certified copy of this order by the concerned district commissioner, which is also the chairman of DLC, if the matter pertains to DLC. In other cases, the chief secretary to the government of Assam, who is the chairman of the SLC, if the matter pertains to SLC. It is made clear that in view of the consent of the parties, this court has not gone into the merits of the petitioner case that are being disposed of by way of this order. And as such, the application for compensation appointment should be disposed of by the concerned authorities on merit, as they deem it fit proper. The decisions to be taken by the concerned authorities should be based on reasons, and the decision taken should be communicated to the petitioners thereafter. It is also directed that while deciding the application for compensation appointment, the respondents cannot take recourse of the impugn OM 18/9/2024. Though the judgment provided there in the case of Debabrata Tiwari can be considered applied by the concerned authorities. It is again made clear that this order cannot be used as a precedent for cases that are filed on 4/4/2025 and thereafter. It shall only apply to those cases that are pending before this court as on 3/4/25. And my case were pending, my lord.
This case was filed on 5/6/2024, 25, Lordship. It is after this judgment.
No.
Therefore, the notice may go, Lordship, but it is not
No.
covered case, Lordship.
Case was, my lord, case was pending. Then Lordship, the withdrawal order. Lordship kindly have a look. Why is saying so? I do not know, my lord. Withdrawal order at page 62, Lordship.
Is pending, but that earlier writ petition, they were telling me that.
Yeah,
It
OM
was
loss.
not challenged.
OM was not
And
challenged.
I've been told to challenge it.
No.
Yes, my lord.
You have been told,
Okay.
My lord, since the
if you come to page number 70, paragraph number 2. All these writ petitions have
yes,
common cause of action. You see, this is the finding of the court, para 2 personally.
para 2. All the writ petitions have prayed for setting aside the page 70 lordship. All the writ petitions have prayed for setting aside the office memorandum so and so 18924 issued by the government of Assam.
There was a prayer for setting it aside.
Yes, Lordship.
And I have challenged now.
No, now challenge, Lordship. It is not
No.
covered to the earlier judgment.
No, since lordship kindly have a look the para 63, my lord. 62 and 63, my lord. All these cases were pending since 2022.
And then you come to the last line of para 10.
Yes, Lord.
Yes.
That is
Ultimate result will be, my lord, that
no.
that has to be considered, my lord, by the authority concerned. It will be remand back.
It is
Earlier
clear.
also,
No.
my lord, this court, my lord,
There is a very specific.
Yes, Lord. The specific direction is there, Lord.
We can issue notice,
Yes.
but say that this is covered.
No, it
Yes,
is not
madam.
covered.
in my humble submission, my lord, I have seen, my lord, so many cases, my lord. Though fresh case
So
have
if
been,
the respondents agree, we have no difficulty closing it. But this order is a consent order.
my lord, yes, consent order, and that is why, my lord, subsequently when cases were filed, my lord, when the matter were pending, after disposal of this main case, my lord, then cases were filed by the petitioners. All these cases were considered in view of this judgment, this order.
All these are consent orders.
Yes.
All the subsequent orders are also consent orders.
Consent orders, my lord, here,
If they give a consent, we have no difficulty closing it.
We are not giving the consent, Lordship. It is the case is very clear, Lordship. Notice may go, Lordship.
in most,
We'll examine.
Yes, Lordship.
in motion, it says these, all these cases were disposed of.
That is the consent order.
But in their cases, if you give consent, why are you not giving
No,
consent here?
Lordship, here it is, Lordship, we have to implement the strict consideration of the court, Lordship. This is the strict consideration. It is stated that the cases which is filed, cases which is filed.
Subsequent thereto, there are some matters which are
No,
also.
Lordship,
Yes.
I am not good for that order, but I am strict on this order, Lordship. It is Advocate General.
Mr. P. Chetri, that are- Five.
Yes.
1, 4, and 6.
Taking a direction to the respondent.
Yeah.
Reconsider the case of the questioner. Against courts, against Mark. The officer will for the-
ঘৰে যাব, অথৰিটি তাতে যাব, তুমি আৰু
Notice to hold up, take for them.
This one.
আমাৰ আগৰ কেছটো কেছ কাভাৰ Pablo.
May I please your lordship? Lordship kindly pass over the matter for timing. He is in court number 9.
The end of the. This can be affidavit filed by record number 2. We need to file a reply on it. 2 weeks time may be allowed. With file the affidavit. Join the affidavit. They are paid. Take it. 4 weeks. They take the- File.
Excise.
Excite. Excite.
May I plead your lordship? May I plead your lordship? Now, this I is for correction of typographical error, your lordship. There has been an inadvertent error, your lordship. And lordship will kindly come to page number 8.
Yes.
Regarding the name of the office, third paragraph, your lordship, instead of assistant register, it should be zonal joint register. Third paragraph.
Yes, what is there, respondent?
Lordship, we have no objection. No, we have no objection.
Instead of,
The assistant register, it should be zonal joint register.
where have you mentioned that zonal joint rate? Is the area is the party?
Lordship, in the Lordship will kindly come to page number 2, your lordship. There is a page number 2 of the
There is no zonal joint rate.
in party also, your lordship. It should be there, and in some typographical error is there, your lordship.
Make corrections here first. In the course title, there is no reference to zonal joint register.
Lordship, I have applied for in the I have also applied for correction of the post title also, your lordship. Otherwise, only notice was issued, only the, as regard the office, your lordship. Lordship, he is not a necessary party in this writ petition. He may not be a necessary party, your lordship.
You see your prayer at page number 5. You're asking for insertion of the word zonal joint register.
Lordship.
But in the course title, there is no prayer that the person should be arrayed as a party.
Lordship, he is not not a necessary party regarding the claim of the petitioner, your lordship.
Then what?
Only he is working there in the office of the zonal registrar. At present, he is working at the, but his avertments are regarding the other office. In post title also, your lordship, page number 2,
I is the fact taking correction. Of 50%. I post title. If the company. So further prayer is made. The correction.
order date.
Order dated 6/25. Submitted by the government. Yes, that is the order dated 6. Reflected that the petitioner was working as PA in the office of assistant registrar like Lora. Whereas not to have been the office of the zonal
Joint register,
cooperative society.
Jorhat. Lordship,
This error has kept repeated. For which I taking correction. Further submitted that
In respondent 4, in place of Khanapara, Your Lordship, otherwise everything is same. In
Yeah.
place of Khanapara, it should be Dibrugarh.
You hear the order.
Okay.
Respondent 4, the state of the port deputy registrar cooperative society. It ought to have been deputy registrar cooperative society Dibrugarh. Similarly, in particulars of respondent 5, state of extent registrar cooperative society it should have been sorry Assam Khanapara, it should have been extent registrar cooperative society. Is correct. Pick up any right? There are representing respondent object that view the rules the particular place before the court taking into consideration made by the pressure out the court the direction in the order dated 6/6/25 to the effect that the writ petitioner working in the office of state registrar property shall be read so you can say the direction the order dated 6/6/2025 showing the petitioner recording that the petitioner is working as an MBA should be read as in the office of National Joint Registrar Cooperative Society at in place of office of the Estate Registrar Cooperative. The petitioner is further permitted to take necessary steps for correcting particulars of response 4 and 5. So far as response 4 is concerned, state of deputy registrar cooperative society. Similarly, far as 5 state of estate registrar cooperative society. It should be estate registrar Dibrugarh. Both are Dibrugarh.
Respondent 5 is Tinsukia, Your Lordship.
It's let the correction be permitted carried out by the registry by the petitioner will file the detailed post time 3 weeks from this order shall be read together with the order dated 6/6/2025 asking the copy of this order should also be retained in case records of WBC 3035. I extend the allowed.
Deeply obliged, Your Lordship.
Lordship, here in this case, Lordship, uh, the affidavit ready, Lordship, and it is sent for execution, Lordship, sent for vetting, Lordship. We'll fix the matter after 2 weeks, Lordship, we will submit in the meantime.
The right. A.K. Goswami. I we listed in the first week of August on the history. The respondent 5 they are happy to get. Good.
Please, Your Lordship, my lord, in this case, my lord, an advertisement was issued, my lord, on long back, my lord, 27/2022, in Extra 4, my lord, to fill up the post of revenue registrar
Lordship,
and administrative officer.
Lordship, some difficulties is there.
Difficulty.
Yes, Lordship. the concerned file is not pressed out.
Which posts is referred here?
Lordship, it is serious revenue serious error
Video there.
and administrative officer.
What is your prayer here?
Lord, my prayer is, my Lord, Lordship will find at page 14, my Lord. Lawfully fill up the post of administrative officer and revenue sales settlement. On the basis of advertisement, my Lord, dated 27/2022.
With my fill up post of revenue sales tax. It's been as advertised by dated 2007. Which post we take it the office the district of the apprehended expressed by the petitioner is that this post may be filled up without following the process of law. And the petitioner being an eligible candidate, you are eligible.
Yes, my Lord.
His case may not be considered by the authority as is required under the rules. There are please report submitted to the basis of instruction that the concerned file being file number MB number 6 of 2022 relating to the appointment of revenue registrar and real estate officer could not be traced to the office of the district of file has been actively searched for necessary communication has been addressed to the competent authority. So, however, since the file remains accessible, the process has not been initiated. So, further submission that it can be taken immediately. In view of the submission made, the third, the units of office. We next day fix the respondent will apprise the court of the status of the file, concerned file relating to appointment of revenue registrar and the same has been traced back. Further, in the next day fix post shall not be filled up without the 11
Deep level.
Mr. A. Kumar or PAD.
Deep level.
May plead your lordship. If you kindly produce last order, 9.
Yes. Rejected.
Lordship, you may be directed to bring this order, lordship, by an affidavit, lordship, then I can file reply, lordship. Otherwise, in this case, no affidavit has been filed till date, lordship.
So, but this order is not under challenge.
No, lordship, just now. So let him bring on record by way of affidavit, lordship.
Bring it on record. Yes. Pursuant to the earlier order, the learned study company the report right passed by the secretary for letter dated 26/9/3 at 1/2/24 filed by the delinquent staff for withdrawal of penalty to rejected. The pending on committed the affidavit of record by filing on the third of February. File their detailed affidavit. In the present resolution. Placed after full.
Obliged.
Mhm. What is the matter about?
Oh, when the use has been, but we have received the piece of idea. Has that come up immediately after getting the petition?
When the earlier order dated 36. Mr. B. Kaushik that at the views. Gave the therefore, short book able the department to complete the departmental investigation. MS Sharma, P. Sharma appeared to be AMP. Let the matter be listed again after 4 weeks.
On,
By
on,
which date-
on 16, my lord,
by
16
which
July.
date the respondents will apprise the court status of the disciplinary proceeding stated to be pending. in the-
My lord, may I just, can it be a direction that within this time frame it may be concluded, my lord?
But he said, will apprise the court.
Yeah.
Endeavor should be made by the respondents department by the next.
16/7, my
21st, 21st, right? 21st, 23rd or 23rd.
deeply obliged.
Inquiry করে
When was it submitted? When was it submitted? Then why do you accept such instructions? When was it submitted? Who submitted? Why do you say that the inquiry report have been submitted before the disciplinary authority? Your instructions do not say that. It only says that inquiry has been complete. Huh? Huh? Then why are you relying on the written instruction?
we have received
When was it initiated? When were the show cause notice served?
Lordship, about 23rd, 29/5 Lordship, suspension impugn order was passed, Lordship. With effect from 23rd/5, I was suspended, Lordship.
Show cause notice. You have not enclosed in it.
Lordship, no so cause notice like.
And how the inquiry is complete? Council for the department is that inquiry is completed in further time. Enable the department. The department proceeding immediately. The step that no department has given the department have submitted to the board that departmental proceeding are completed. But inquiry against decision are completed. Further time by the proceeding that the proceeding.
But the date may be fixed. No?
6th of August.
Right.
Yes.
My lord, may kindly place the order dated 2nd of June, my lord, last 26/25. This matter pertains to AFDC, my lord, Fishery Development Corporation. The petition was demoted to the lower rank.
Yes.
I need some time. My officer is on leave and again, he has resumed the duties, lordship, because he is in chairman of the SLRC, State Level Equipment Commission, lordship.
Now, what has happened in the meantime? The petitioner,
Now he is in the lower rank, he's working,
lower rank.
lower rank.
So, only after his,
And there was the last split go by to the procedure, my lord, disciplinary rules in this case. Ultimately, the lordship will, my prayer will be, my lord, because lordship will not set aside the shock of notice. That is also my prayer. Ultimately, lordship will see that the total violation, and lordship will probably set aside and send back for de novo inquiry. That will be ultimate, wherever it goes, my lord.
Why do they legal?
Because, my lord, if your lordship kindly see the impugn order. Before that,
You order
yes, page number 81.
81.
Yes. There's a proceeding they've drawn up under rule 9, 4 and 5, my lord, disciplinary rules. And can you see the last page number 82, the operative part, then I'll show my lords. Demoted and withdrawal of or retirement whenever he, in future he retires, my lord. That is the meaning. Now, one example I'll show how they proceeded. Please come to page number 75, the inquiry report.
When is he retiring?
No, retire time, still time is there.
He's got.
If time is there.
Yes.
What is his age now? Age, what is his age? 27, I think. He's 57 years now. Now, lordship is seen, my lord, inquiry report page 75, and the left side, kindly see perused serial number 6, just below middle, page 75.
Right.
Yes. Left side perused, lordship, kindly see serial number 6. That's one inquiry report.
What is DFI?
That's what, my lord. I think this is my learned friend can say, my lord, because in the shock of notice, page 31. Please come to page 31.
page 31, my lord, kindly see. This is a proceeding, second paragraph under rule 7 of appropriate service rule. And please come to page, my lord, 34, page 34. Allegation against Jyoti Prasad Saikia. Kindly see, no list of date, no list of documents. If there is a list of documents, they could have mentioned the DFI report, nothing is there. Number 2, this matter was dealt by your lordships on earlier occasions, my lord. Lordship, kindly see your lordship's order also, my lord. That's in page number, my lord, 66. This is the second occasion. It starts in page number 63. What happened, my lord? After Shoga's notice, straight away, they passed an order directing me to return 76 lakhs, my lord. Straight. So lordship has stayed that order. Without disciplinary inquiry, how can that be, my lord? So page number 63.
What has happened to the writ petition pending?
That-
This writ petition,
That is pending. That is pending. Kindly see, lordship has stayed this one. After that, page number 67, and Barnicular is page number 68. They have appointed inquiry officer. Inquiry is a very fast day. He called me. My statement was recorded, and next day inquiry report was submitted. And he perused those documents, my lord, which are not in the Shoga's notice. Nothing, my lord. Complete go back to the appeal notes 9, 4, 5, 6, 7, 8. Nothing.
already heard. The P. Sharma letter. It instructed the great. How much time do you require?
Lordship, in the last end of July, Lordship.
For directly. $28.
Lordship.
July. Both the writ petitions could be listed together.
Fine, that can be done. That's itu balik. Ayo যেগুলো তাই
It's not 28.
আপনার
The matter pertains to Milot post regulation and service Milot after his retirement. He responded number
One affidavit we have already filed, Lordship. Lordship, I think subsequently also, Lordship, one order was there. It was an order of 2023, by which, Lordship, a decision was taken not to regularize his service, Lordship. That particular document is not in the affidavit, Lordship. So if Lordship permits, I can bring this document in by filing an affidavit. Otherwise, Lordship, by placing also this can be done, Lord.
Bring it on record. Let
Lordship.
him have benefit of. I think any rejoinder review on.
Additional.
Are they? That there is an order.
Lordship, petitioner was appointed on 3F basis, Lordship, and during his service period, his service was never regularized. And in that status only, he retired from service. The file was subsequently processed before the authority, whether his service can be regularized or not. And it was ultimately decided, no, his service cannot be regularized. That particular
the claim petitioner regularizing and the claim was that by public not be brought filing the affidavit by the state. It may be therefore everything. 4 weeks.
Obliged.
On 12/3/25, my lord, directed the respondents to inform the board that whether the 25% quota for promotion was indicated giving publishing the advertisement.
Here,
Lordship, some more time is required, 1 week, Lordship.
will take you filling up 25. Yes. August.
Obliged.
Mayor, with your order. The matter pertains to charge from charge.
Reading the complete.
Yes.
Readings complete.
Issue rule matter come up here.
Lordship.
2020
Matter of
matter,
discharge.
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 Lordship. My contention is that this order is punitive as well as stigmatic.
Will exam.
The
Yeah.
rule line is not followed. That may fix not.
Of August.
Month of August, any day. Lord.
Date will be fixed by the rates not. Date.
Obliged, Lord.
Just 1 minute. Mr. Sharma, your files somewhere is in transit, so we'll call it up after the file comes. No. Yes.
Petitioner has served a copy, Lordship, of the Honorable Capital Tribunal granting consent, Lordship, giving consent for arbitration.
What has he submitted?
Lordship, consent has been given, Lordship, for arbitration, Lordship.
For arbitration
Arbitration.
by the petition, by the
It is served by the petitioner, Lordship.
proposed arbitrator.
Lordship.
Pursuant to the direction in the order, 5/6/2025. Whereby Sri Mrinmoy Kumar Bhattacharya, retired district and session judge Assam, was proposed to be appointed as the arbitrator to decide on the disputes arising by subject to furnishing of the written declaration. The parties have placed before the court the written declaration 12-1 of the Arbitration and Conciliation Act 1996, dated 19/6/2025, whereby the proposed arbitrator has expressed no difficulty or any handicap in being appointed as the arbitrator. Copy of the declaration is kept the record. It's so that view of the matter, the arbitration petition stands allowed disposed of. Mr. Moy Kumar Bhattacharya, former retired district and session judge Assam, is appointed as the arbitrator to decide arbitrate on the disputes arising by and between the parties pursuant to the contract agreement number CWE hyphen TEZ within bracket 859 bracket close slash 02 of 2018-19. Is that the agreement number?
That's it.
Copy of the said disclosure is also available in the case record and was submitted to the registry by the prospective arbitrator. View of the orders passed. The parties will now appear before the learned arbitrator on within 4 weeks.
That's it.
From today, and place a copy of this order. Thereafter, the learned arbitrator will initiate the proceedings. Arbitration petition disposed of in terms of the
Obliged.
a copy of this order be communicated to the learned arbitrator by the registry of the court.
Obliged.
Lordship, similar matters are heard by this honorable court,
Definitely.
Lordship. Those matters are fixed on in the month of July, end of July. Lordship, being read petition number 2301 of
What similar matter?
Lordship, this matters pertains to the PWD category candidate, Lordship. They have applied for some advertisement, Lordship, and subsequently they were not given appointment since their medical report.
Disability status.
Yes, disability status.
When is the matter? When
End of July. No such date, Lordship. End of July.
End of July.
My lord, those matters are on a different tangent. Because in those matters, the OM which says that reassessment should be done, that is under challenge. I am not challenging that OM. I am challenging the outcome of the medical board which says that my disability is 23%.
Same, Lordship.
So it is not that I'm challenging the act of the state authorities in conducting a reassessment.
What is your what is the ground on which you are challenging it? The
My lord,
medical report.
My lord, after my test was conducted by the medical board, I went for an independent test at GMCH. And from the inference of the medical report, it comes that my accessibility is 57.1%. If I assess my disability, it will come at 57.1%.
How will the court decide?
My lord.
Whether what are the parameters to decide the medical board result is incorrect and the subsequent test that you undertaken is correct? What is the parameter?
My lord, then the medical report.
To opinion.
Yes, my lord.
These are to medical opinion.
My lord.
Given by medical expert.
My lord.
Is it your case that the medical board, you belong to which category of PWD? What is your disability?
Hearing disability,
Hearing.
hearing disability.
So is it your case that medical board did not have ENT specialist?
My lord, my case is that the BERA test that is conducted, a BERA test usually takes 40 minutes time, but my test was conducted for only 5 minutes. So my test was not conducted properly, due to which the result that came is erroneous. And on that day, around 100 candidates were assessed on the same day. So every candidate got around 5 minutes. That's not enough for BERA test. And there has been no affidavit on the part of the medical board or the health department as to whether my claim is correct or incorrect.
What about the pleadings here?
Lordship will file our affidavit, Lordship.
Then you file it.
Yes,
We will decide on that
yes, Lord.
issue. Whether it is permissible, not permissible. What test are you referring to?
BERA test,
BARA.
BERA,
BER.
BERA.
And on what basis are you saying that it requires what? How much time it requires?
40 minutes time.
40 minutes.
There's the general. A BERA test generally takes 40 minutes time. I don't have any documentary evidence to here, but that's the general time that is required.
No, but how will the board determine whether this test was conducted for 5 minutes or 40 minutes? Is there any, is the time factor mentioned in the result?
No.
Then?
That's not there, but on the same day, 110 candidates underwent BERA test.
So 40 minutes into 110.
110. Now, in a single day, from 9 a.m. to 6 a.m., if we calculate, it will be around 540 minutes. Not possible all of them go same test.
Yes,
Lordship will file our affidavit.
bring it.
Yes, Lord.
These are serious allegations being raised.
Yes, my Lord.
So please file a comprehensive affidavit explaining all the allegations.
Yes, Lord.
Yes, ma'am.
Heard, Mr.
Ekhan.
Ekhan, counsel appearing for the petition. Mr. D. Upamanyu appears for L.
Yes, Lordship.
And Mr. Chaudhary for
For SLRC, Lordship.
SLRC.
State level recruitment committee. It is, Lordship, respondent number 4,
SLRC.
3 and 4.
Ms. A. Talukdar appears for respondent 1 and 2. Mr. Your name. C. Pudagohai appears on behalf of respondent 789. RB Goswami for 10. The respondents are permitted to file their affidavit within 4 weeks. The petitioners may thereafter file their rejoinder affidavit if so advised.
My lord.
It's taken up to 4 weeks.
My lord, a date may be fixed if possible.
Let them file the affidavit.
Yes, my lord. My lord, there is a connected IA in which I have prayed to keep those posts vacant in which I was declared to be qualified.
How many posts? How many petitioners are there?
It's the only single petitioner, one petitioner. I was declared qualified for 2 posts.
So you can only be allowed to take place, appoint in 1 post.
Lordship, he applied for 2 category. And Lordship, all those posts that were already filled up. Now only is the concerned PNRD department can say whether there are vacancies or not. Because in the subsequent another recruitment process has been completed. Now the interviews will be held.
We'll take this IA along with the writ petition. It will
Okay.
be listed on 4th of August.
Man, obliged.
Okay.
4th of August.
May I please, Your Lordship? Your Lordship, Mr. Aibor Thakur of the State Respondents, Your Lordship, has requested me to pray before his honorable court, Your Lordship, to fix the matter to Your Lordship. He's held up in another.
Today at 2 is not possible.
Your Lordship may fix a short date, Your Lordship, before the vacation.
Before the vacation.
Yes, Your Lordship.
All right, Wednesday?
Yes, Your Lordship.
Wednesday. Which item?
Item 28, Your Lordship, on the last
28.
occasion, Your Lordship.
Matter be listed on Wednesday.
Yes, Your Lordship. Much obliged, Your Lordship.
May it please your lordship. My lord, if your lordship should kindly come to earlier judgment of this honorable court at page number 126.
Yes.
Para 33 and 34. As noted above, in the present case, the departmental proceeding and criminal case are based on identical and similar set of facts. And the charge in the departmental case and the charge before the criminal court against the petitioner are also one and the same. The listed witness in the departmental case were examined in the criminal case, and criminal court upon examination of such witness has concluded that prosecution has failed to establish that petitioner accused had demanded illegal gratification from the informant. That being so, in the considered opinion of this court, the further continuance of the departmental proceeding against the petitioner is wholly unfair and unjustified. Accordingly, this court deems appropriate to dispose of the writ petition in the interest of justice by directing respondent authorities to conclude the departmental proceeding, which is pending against the petitioner in accordance with law, by keeping in mind the observations made herein above within a period of 1 month from the date of receipt of certified copy of the order. Because this honorable court came to the definite conclusion that since the departmental proceeding and criminal cases are grounded on the same set of allegations and same set of witnesses, therefore, since there is an acquittal in the criminal case, therefore, departmental proceedings should stand concluded. Now, my lord, naturally, honorable court will not do in a, judicial review power. So 1 month time was given to them to close the proceeding consistently with the observations made in paragraph 33. Now, instead, what they did, my lord, they filed an application seeking time. Now, an order was passed at page 137, my lord. Sorry, my lord, at page number 135. Now, if your lordship should kindly come to page 134, my lord. Para 33 and 34 of the earlier order is noted. Then kindly see, my lord, the subpara. A perusal of the aforesaid paragraph indicates that though the criminal court has acquitted the respondent for the same set of charges, the departmental proceeding has not been concluded by the state government, and accordingly this court directed state government to conclude the departmental proceeding, which is pending against the respondent in accordance with law, by keeping in mind the observations made in the preceding paragraph of the said judgment and order within a period of 1 month from the date of receipt of the certified copy of the court's order. It appears that pursuant to the judgment and order dated 29/10/24, the respondent has taken necessary steps for appointing an inquiry officer from panel prepared by the personnel department. It further appears that respondents are moving slowly in the matter. Before adverting to dispose of the matter, this court on 8/1/24 requested Sri D. Nath, learned senior additional so-and-so, to apprise the court as regards the reasonable time within which the direction passed by this court should be complied with. Today, when the matter was called for, D. Nath, learned additional senior government advocate, submits on instruction that a further period of 3 months would be required to conclude the departmental proceeding. It appears that the departmental proceeding against the respondent is pending for a long time despite conclusion of the criminal trial, resulting in acquittal of the respondent. In the considered opinion of the court, the further period of 3 months in the context of the present case appears to be unreasonable, and as such, directed the state respondents to conclude the departmental proceeding as directed earlier by this honorable court, strictly within a period of 1 month from today, failing which adverse consequences in accordance with law shall, if required, be faced with. That means, all that the honorable court said was, we cannot give more time to conclude the proceeding. We are giving further 1 month's time.
Despite this, my lord, the impugned order at page 136. Now, this honorable court never permitted any further inquiry, my lord. Kindly see. This is the impugned order which has been stayed by this honorable court.
Page
Whereas
number?
page 137. Whereas an inquiry under Rule 9 of the Assam Services Discipline and Appeal Rule 64 is being held in respect of the charges framed against Bhupesh Chandra Das, ACA Joint Secretary, Skill Employment and Entrepreneurship Department, with show cause notice dated 9 to 18. Whereas Monimala Fukan Bortakur IAS, the then state inquiry officer, was appointed as inquiry officer to hold inquiry into the charges against Bhupesh Chandra Das, with notification dated so and so. Whereas Monimala Fukan Bortakur retired and then Atika Sultana IAS, the then state inquiry officer, submitted inquiry report dated so and so. Whereas disciplinary authorities of the opinion that further inquiry is needed in this case on the ground that some serious defects crept into the previous inquiry from the stage of recording evidence as statement of important witnesses listed in the show cause notices were not recorded by the earlier inquiry officer, and also considering the fact that Atika Sultana IAS retired on 31/12/22. Therefore, the governor of Assam, in exercise of the power conferred under sub-rule 4 of Rule 9 of the so-and-so, hereby appoints Sri so-and-so IAS Commissioner Secretary to inquire into the charges against the Bhupen Chandra Das. Hello, where is the scope of appointing this inquiry officer? This honorable court says that the disciplinary authority itself is bad because there is an acquittal in the criminal case. Now that order has attained finality. Nobody has filed any appeal against this order. Now, my lord, that 1 month time is over, then further 1 month time is also over. Therefore, they should close this proceeding, my lord.
While the court had directed the issued the earlier direction,
Yes.
the inquiry was pending.
No, my lord, this honorable court came to the conclusion, yes, inquiry was pending, came to the conclusion that in view of the acquittal in the criminal case, further inquiries, departmental proceeding is unjustified. That order has attained finality. Nobody has preferred any appeal.
Inquiry had proceeded.
Yes.
At that time when the court had passed the.
No, apparently, my lord, it appears the disciplinary proceeding never came to an end.
No,
Be that as it may, my lord.
no, it did not come to an end.
Yes.
Did it actually commence?
It commenced.
It commenced.
It commenced with the
Because-
appointment of inquiry officer and
Because
all.
by the impugned order, some presenting officer has been nominated.
No, no, my lord. What I am saying is, yes, now they want to do a further inquiry. Now, on the face of para 33 of the judgment at page 133, whether there is any scope of further disciplinary inquiry. When the honorable court says that the disciplinary inquiry itself is bad in law.
Yes.
So my humble submission is, Miller, otherwise my IAS nomination is pending because of this, Miller.
Yes.
Initially, 1 month period was given. Subsequently, when time was prayed for, another 1 month was given. So that 1 month also came to an end, my lord, on, that was given on 9/1/25. So on 8/2/25, that 1 month is also over. The further inquiry, there is no scope. So therefore, my lord, my humble submission is, this repetition should be allowed and this proceeding should be closed, my lord. Every time court will not go on directing, my lord. If they do not do, court itself will have to be do.
Yes. What do you think?
Go to paragraphs 5 of my affidavit of additional. That the
Paragraph
164.
5 of your affidavit.
Yes, Lord. Additional.
Additional affidavit.
The affidavit filed on 6/06/2025. Lord.
Filed by Ritu Porno.
Yes, Lord.
Yeah. There are 5.
Yes, Lord. Imdadul Hussain, filed by Imdadul Hussain. Additional affidavit in opposition, Lordship.
Additional affidavit.
Yes, Lordship. It is page 164, Lordship, running page. the deponent further begs to state that by the order dated 06/03/2025, this honorable court directed the respondent to obtain the instruction whether the departmental candidates junior to the petitioner are being considered for nomination of IAS cadre or not, and if so, whether steps have been taken to consider the petitioner's case. In this regard, the deponent begs to state that a list of the eligible SCS officers for nomination to IAS for a particular select year has been prepared based on the consolidated seniority list as on 1st January of the select year, and no departmental candidate junior to the petitioner in the consolidated seniority list as on 1st January of the select year are being considered for nomination of IAS cadre. For the select year 2023, there are 4 vacancies to be filled up for SCS officers for promotion of IAS cadres, in which there are 12 officers in the June of consideration, and Sri Bipasa Chandra Das is one of them, and he is at serial number 4th position in this list. The deponent further stated that there are laid down rules and procedures in the Indian Administrative Service appointed by the Promotion Regulation 1955 for appointment of the promotion of the state civil service officers to IAS. As per the said regulation, there is no provision for seal cover in case of any candidate against whom the departmental proceeding or the criminal proceeding is pending. Regulation 5 bracket 5 of the Indian Administrative Service appointment by promotion regulations 1955 states that the inclusion of the name of the officer in the select year shall be treated as the provisional if the state government withdraws the integrity certificate in respect of such an officer or any proceeding. Departmental or criminals are pending against the officer or anything adverse against him which rendered him unsuitable for appointment to the service. Yes, sir.
Tell us
Yes.
whether any appeal has been filed against the directions of the courted bench earlier.
Lordship, appeal, Lordship, I don't think. Not.
If you have not filed, then you are bound to comply with this order. It's written in plain English. Does it require so much of effort to understand what is the direction of the court?
But Lordship,
There is the categorical finding that cannot be is unjustified.
Lordship, matter kindly fix the matter tomorrow or day after tomorrow, Lordship. I will apply it.
Milord, every time a different government advocate appears and this is what is going on, Milord. Milord, my learned friend is trying to deal with an incidental issue. Naturally, my lord, under regulation 5.5, if the Milord integrity certificate is not given by the state government, then UPSC will not consider my case. That is what the state wants to say. My lord, that is an incidental issue. I am on the substantive matter. Now, this honorable court's observation has attained finality. Now, in view of that, they should close it. Instead, they are issuing show cause notices, one appointing inquiry officer, one after another, when honorable court says that DP itself is not.
When is your election like to take place?
It is already started, Miller. Because of this pendency of the proceeding, they will not give the integrity certificate.
We'll have it immediately after reopening.
Yes, Lord.
No, Lord, I think they should close it, Milord. What else they will do, Milord?
But then we need to know why you are not doing it.
No, Milord, every time a different government advocate appears, then different stand is being taken.
I assure that I will appear in the next box. I will appear.
It's not a, no, my lord, issue is, as your lordship has rightly pointed out, whether any appeal has been filed against that order. That order, no, instead of filing an appeal, they file an application seeking time. When honorable court says we cannot grant 4 months time, we'll grant 1 month's time. The idea is you close the proceeding, then everything will be in place. And earlier also Dipankar Nath appeared, he said they have not filed an appeal. That is the instruction which my learned friend will take. Let him take at 2 o'clock, whether any writ appeal has been filed. All that I am saying is, my lord, unnecessarily this proceeding is dragging on, therefore, my lord, I am not getting the benefit. Because they will never give me the integrity certificate as required under regulation 5.5 of the IAS regulation by promotion, my lord.
The proceedings are under stay.
Yes, now the impugned show cause notice at 137 has been stayed by the Honorable when we move the motion.
Yes,
Any date, Lordship, can you fix any date?
we need to know what are you doing with regard to the
Yes,
directions in
I will look at
para 33.
I will
That's all.
I will look.
Let us have it after vacation because
My lord will give a fixed date. my lord.
we'll have it on 15th of July.
Yes.
It's on 15th of July again. As the learned government advocate, Mr. We are recording your name.
Yes,
Mr.
Lordship.
J. Goswami,
Lord.
additional senior government advocate, 6th time
Eh?
to apprise the court what steps have been taken
I'm already said.
to by the respondent department. In respect of the closure of the departmental proceedings, as have been directed by court and bench earlier by the judgment and order dated 29/10/2024 passed in WPC number 1053 of 2025. Let these instructions be placed before the court on the next day. An attempt will be made to dispose of the writ petition on the next day.
Instead of 15, could it be 17? my lord?
The senior counsel assisted by
17.
it's on 17th.
17,
Yes.
Lordship.
Deep lord.
17th.
Okay, on the last occasion, Lordship, your Lordship directed to receive instruction. Perhaps they have not.
Lordship,
received as-
or we have been supplied with a different communication. The communication which your Lordship had directed us to get, that 1912, we've been given a different one. So, we request your Lordship to give us some time. We'll obtain the proper one. The 1912-2024.
Yes, how much time do you require?
So we listed immediately after vacation.
Yes. Mr. A.T. Sardar, learned petitioner, Mr. Bhuya. Learned counsel is liaising for the health department,
This would be NHM, Lordship.
NHN.
Lordship.
Mr. Bhuya submits that the communication dated 19/12/2024 issued by the Joint Director in Services, which the court, which they were permitted to visit before the court. The appropriate submits that the matter be listed immediately on it's from 18th July.
Much obliged.
Lordship, interim order partially may be continued.
Interim order passed early will continue. Legal negative fix.
Much.
I'm sorry, my lord.
Yes.
Could not take one minute from call, my lord. This matter, my lord, the petitioner is an employee of the LIC Housing
You
Finance
know the
Limited.
transfer matter, transfer. You know, you are challenging the transfer.
Yes, Lordship.
So you know the parameters on which transfer can be interfered with, very limited.
My lord, basic defense here is that, my lord, one remark has been given that non-performance. That is the prime challenge here, my lord. Basic challenge. But the, my lord, LIC and LIC Housing Finance Limited is the main respondent here, but they have not received copy, my lord, advance copy. My
Which
lord-
order are you challenging?
My lord,
Where is the impugned order?
my lord, impugned order is at page, my lord, 40.
40.
Yes, your lordship. My lord, CL number 12, my lord. Here in column
Serial
number,
number
serial number 12, my lord.
12.
Nissan Anand.
What is wrong with this order?
My lord, wrong is that, my lord, transfer, within bracket, it has put a remark that non-performance. But as per the petitioner, my lord, he is doing well, my lord. This order is,
Your perception.
no, my lord, it is arbitrary also, my lord.
You are not the only person. There are several other persons.
Some other persons are also there, but my lord, what happened? He is a cluster head, my lord, of Guwahati cluster, my lord. Under him, there are 7 area offices. Out of that 7 area offices, 4 area offices has done well, my lord. 3 has not done.
From where do you show it?
My lord, 3 has not done well, my lord. It has been, I have annexed 3 letters at page 46, 47, and 48, my lord. At page 46, my lord, here area manager test floor, my lord. He is not doing well.
So what is the parameter for the authorities to decide?
My lord, that is the main issue here, my lord. There is no such rule, my lord, governing the transfer and promotion, etc., my lord, and posting. Therefore, my lord, they are arbitrarily, my lord, doing this, my lord. That's why I have.
You are presently posted in Guwahati.
Yes, your lord. Currently posting in Guwahati as cluster head, my lord.
Who is arbitrarily issuing that order?
My lord, general manager, HR.
Then you have to array him as a party by name.
My lord, general manager has been made party, my lord.
Where is is there any transfer policy? There must be.
My lord, there is a guideline issued, my lord.
Where is that?
Floated through internet, my lord. It is Annexa 13, my lord.
Page number?
Page number, my lord. Page number, my lord, 61. As per this guideline for transfer, my lord.
61.
61, my lord.
Yes.
My lord, here at row third row, my lord, 1.3. As the petitioner is in the rank of associate chief manager, my lord. My lord, for change in department within the office, once the employee has completed 4 years.
Petitioner is in what rank?
My lord, associate chief manager.
Associate chief manager. He falls under which category?
My lord, here 3.
1, 3.
3 divisions are there. Last one is
1, 3.
my lord, 1.3.
1.3.
Yes, your lord.
He is a chief manager.
Chief associate chief manager.
Associate chief manager.
Here some criteria has been given. Change in department within the office once the employee has completed 4 years or more in that department. My lord, here the petitioner appointed as cluster head on 23rd of May 2023. 23.
Then?
Before that, he was posted in Guwahati, my lord.
All right,
On
then
20.
next criteria.
Next criteria, my lord, change in office within the city once the employee has completed
This
5
is
years.
within the same area.
Yes, my lord, same area. 5 years or more. Change in city once the employee has completed 8 years or more in same city. Change in state once the employee has completed 10 years. Now the petitioner posted at West Bengal, my lord, Kolkata. Change of state. He has to complete 10 years, but the petitioner only completed in Guwahati office 3 years. 2 years completed, running 3 years.
Anyone for the respondent?
My lord, regarding respondent, my lord, LIC and LIC HFL has not received copy, advance copy, my lord.
I heard Mr. M. Soikia, Learned Government Petitioner, the petitioner is free by the Pune order of transfer dated 24th of April 2025. whereby several officers have been transferred across the country. Name of the petitioner appears at serial number 12. The petitioner has been transferred from the Guwahati cluster to the Kolkata cluster as a credit manager. So, the transfer has been effected by purportedly for the reason of non-performing inputs. Learned counsel for the petitioner submits that this non-performance is not supported on materials, as the petitioner is presently serving as cluster head Guwahati cluster, and under him, how many officers?
7 area offices there.
7 area officers are there, and according to the counsel for the petitioner, without proper assessment, the performance of the petitioner cannot be decided by the authorities. So it is further submitted that there is a policy guideline in place in respect of the officers working under LIC. Guidelines are for transfer and posting for the financial year 25-26. So, for your referring to the said guideline, counsel of the petitioner submits that the writ petitioner falls under category 1.3, as he is an associate chief manager,
Associate chief.
and he was posted in Guwahati on with the from
On my lord, as per order, dated my lord. Order dated 7th of May 2023.
Where is that order?
That is at page 32, my lord.
On 7th of May 2023. So, in terms of the guidelines, the associate chief manager can be transferred by change in the department once the employee completes 4 years more in that department. That apart, his state, he can be transferred out of the state once the employee completes 10 years or more in the same state. So it is submitted that the petitioner did not complete. How many years did he complete?
Only 3 years, my lord, running.
Is completed only 3 years, and therefore he does not fall into any of the criteria prescribed under the guidelines for transfer and posting for financial year 2025-26. So under such circumstances, the transfer order in respect of the petitioner, showing it to be on the ground of non-performance, contrary to the guidelines itself, and is not based on proper evaluation of his performance. So he therefore submits that the transfer order be interfered with, and respondents be called upon to explain the grounds and reasons for giving effect to the transfer order, impugned transfer order, until such time the transfer order be stayed, until such time the respondent show forth transfer order stay. Mr. Stoichia, on the other, also submits that there is no standing counsel available for LIC. And, but on notice being issued, he will take all steps necessary to serve copies. There are accordingly let notice issue, returnable 4 weeks, steps on all the respondents by registered post AD, as well as usual course within 3 working days.
Hello.
So, considering the submissions made by the counsel for the petitioner and upon perusal of the guidelines referred to in writ petition, and as well as the averments made in the writ petition, it is seen that the petitioner has completed about 3 years in Guwahati, in its present place of posting. There is no averment that the petitioner had continued to be in Guwahati prior to his appointment or promotion to the present department. So therefore, in terms of the guidelines, it is seen that a person can be transferred out of the state only after completion of 10 years. So under such circumstances, this court is prima facie of the view that the impugned transfer order, insofar as it relates to the petitioner, is in conflict with the transfer guidelines issued by the LIC itself. Let the matter be listed again on 28th of July. Till the next date fixed, the impugned transfer order dated 24th of April 2025, insofar as the petitioner is concerned, shall not be given effect. Only insofar as the petitioner is concerned, shall not be given effect. Based on 20.
Congratulations.
Are we okay? Right. Yes.
Sorry, Lordship, in this matter, Lordship, this petitioner returned last year, Lordship, about 6 months back, Lordship. Lordship, while he was discharging duties as executive engineer at Golaghat, Lordship, some of his acts came under CBI inquiry, Lordship. And inquiry was conducted in terms of a direction issued by the Delhi High Court. Lordship, that report was placed before the Delhi High Court, and the case is still pending before the Delhi High Court.
No, he was supposed to give us information with regard to the opinion or whatever is to be rendered by the judicial
Lordship, so
department.
far as judicial department opinion is concerned, they have already offered their opinion. Subsequently, Lordship, it has again been placed before the learned Advocate General, Lordship, and it was very recently, Lordship. Very recently, Lordship, after the judicial department offered his views on 16/6, Lordship. Thereafter, it was sent to the office of the Advocate General, Lordship. Whether in 6 during the pendency of the case before the Delhi High Court, whether and no due certificate can be issued or not. That is the issue for the authority.
What is pending before the Delhi High Court?
A writ petition is pending, Lordship.
Filed by?
Filed by two of the two contractors, Lordship, in fact. In that case, Lordship, one subcontract was allowed without the approval of the authority. That issue came under investigation by the CBI.
No due certificate is to be issued if you find that there are no dues receivable from the respondent.
Exactly,
That is the
Lord.
issue, Lord. That is the issue, Lordship.
My Lord, your Lordship will kindly see page 65. It is because of the action on the part of the respondent number 5, they are unable to pay provisional pension to the petitioner.
No, provisional
there is
pension is under process, Lordship. Today itself, Lordship, that proposal is going to be submitted. That instruction I have lost. It is going to be submitted. The date is given 23/6, Lordship.
And regarding the other regular pension, let him get the provisional pension first.
Yes,
because
let us-
the no
let us
due
process the
certificate has not
provisional
been
pension
given.
First, Lordship.
How much time do you require to process the provisional pension?
Provisional pension, Lordship, so far as my instruction, but now we are preparing the provisional pension after solving the same, and the pending provisional pension will be submitted on Monday, that is 23/6/2025. That is today, Lordship. So let us first issue the provisional pension.
How much time?
Let it be on Friday. He's saying on Monday today
Yes,
they are
Lordship.
going to
On
take
Friday,
action.
Lordship, I will
Friday.
be able to
Okay.
give you.
Please take
No, I'm not saying that. I'm not saying that on Friday it will be issued. It will be paid to him, Lordship. But what is the status, Lordship, that I will apprise you, Lord. on Friday.
Yes, that will do.
All right, list on Friday. Mr. E. Nayok, additional AG, will apprise the court on the status of the proposal for grant of provisional pension to the writ petition. Mr. B. D. Das appears senior counsel assisted by Mr.
Lotha,
H.
my lord.
Das, appears through the seat.
Obliged.
List on Friday.
Obliged.
Yes. Time for respondent 4 years.
Mr. R. Boro for respondent 5.
4.
4.
Obliged.
May I please your lordship? Your lordship, the arguing counsel, Mr. H. Sharma, is on legs in court number 14, your lordship. Your lordship may pick up this matter after some time.
Sometime. Let us have it in after vacation. Matter be lifted after vacation. Date will be fixed by the registry as the counsel for the petitioner. He is stated to be not available to appear before the court. The matter is called up. There are or appears for
Eighth or-
another.
Eighth or-
Eighth or appears for another.
Another.
After vacation.
Obliged.
We thought of disposing it off in court, but it will be a fairly long order. So we'll pass orders today in chapter. You are filing the writ petition challenging the termination.
Yes, your lord.
And your ground for challenge is essentially that you have not been given an opportunity of being heard.
Yes, sir.
And but you have not raised the for reference of the matter to arbitration. You have not raised the demand for arbitration.
We have not.
All right. We will pass orders. We are dismissing your writ petition. We find no grounds to invoke our writ jurisdiction here. But we give you liberty to invoke the provision for arbitration if you feel like. You may approach the authorities. Dismiss. We'll pass orders. We should get it, if not today, by tomorrow. Mr. Sharma, I think your matters will have to take it up.
Yeah.
In the second.
At 2 or tomorrow?
Tomorrow. Tomorrow ki hai? We'll have it tomorrow.
Yes, sir.
ठीक है ना फिर? बोलिए ना तो। We'll take it up tomorrow.
Yes, sir.
These matters have all been heard. We have received the written arguments. So we'll close it. Reserve it for judgments.
Much obliged.
So item numbers 1, 2, 3, 4, 5.
Yes.
We are reserving it for judgments. Hopefully you should get it immediately after the reopening.
Much
Is there
obliged.
any further submission that you'd like to make with
No.
regard to any of the matters?
No, my lord, no.
All right. Heard counsel for the parties. The judgment's hearing is complete. The counsels have also submitted short written synopsis or arguments. Matters been heard, reserved for judgment.
Much obliged.